Hello, welcome back to Labor Law for Paralegal Counseling training. Today, or last time we looked at, we started the subject law relating trade disputes, and we looked at most we looked at the introduction on the disputes. We defined the disputes, and we looked at also how do we resolve the trade disputes. And we talked about three things, or four ways of handling labor disputes, or how we can be able to resolve labor disputes. Number one, we talked about negotiation. We also talked about the mediation. We talked about arbitration. Then we also we gave the introduction to the other way of dealing with disputes. It's going to court. So we now, in going to court, we need to understand what will the law state about some disputes. This is your host, Dr. Tulipo Mwenifumbo. So I said we talked about negotiation, mediation, uh, arbitration, and going to court. These are the four trade dispute solutions that they are now. Today, as I said, we are going to look at going to court. What should you use? What does the law talks about? Because when you go into court, courts, they act upon what is written, and anything that is not written does not exist. So you need to be cognizant, and you need to be familiar with the laws, even when you are negotiating, even when you are mediating between the employers and the employees. It is very much important to understand the laws that governs trade unions. I want us to know that the Industrial and Labor Relations Act is the act that mostly talks about the disputes between the employers and the employees. So it outlines the possible disputes and how they can be resolved. So when you go before the civil court or the industrial relations court, the thing that is going to be looked at, it is the Industrial and the Labor Relations Act. So the act provides for the formation of trade unions and employers representative organization, including matters related to dispute resolution in employment. So the act has given the powers to the employees to create organizations, and also to form their representatives in the matter that relates with the disputes. So we look at now there's some sections in the Industrial Relations Act. There is this section 85A of the Industrial Relations Act, which defines industrial relations matters to include any matter. So there is a definition that they give when it comes to disputes. They said defines industrial relations matters to include any matter affecting the requirements, obligations, and privileges of employees, employers, and their representative bodies. So it defines that the Industrial Relations Act deals with the matters to include any matter affecting the requirements, obligation, and privileges of the employees and employers and their representative bodies. And also section 85A Article 4, it talks about it empowers the Industrial Relation Act to make any order or award as the court may consider fit in the circumstance of the case. So the Industrial Relations Court, it is also mandated to, it is empowered in this Industrial Relations Act to empower and to make an order to award the employees or the employers in relationship to the act or the disputes. So there is Article 187 of the Labor Law Act, Act 6 of 19, Article 66 of 1995. It talks about the unfair dismissal. So automatically unfair dismissal are covered in 187, Section 187 of the Labor Relations Act. So it says it's an automatically unfair dismissal is distinguished from an ordinary dismissal. So this article talks about what they term as unfair dismissal. A dismissal for reasons relating to the employee's conduct, capacity, or the employer's operational requirements. So it defines, it guides on what is called unfair dismissal. So when you want to look at the unfair dismissal, you check on Section 187 of the Labor Relations Act of 1995. So there is also dismiss employees. So Section 189 of the Labor Relations Act permits employers to dismiss employees for operational requirements. So there are what is called operations requirements. These are defined as requirements based on economical, technological, structural, similar needs of the employer. So in this article, the employers, they have got the rights, or they have been given the privileges of dismissing the employees when there is an economical or operational issues. For example, there is an adjustment in the operation, so they can terminate the contract of the employees, or maybe there are faults that are found which are affecting the operation of the company. So in that case, the Labor Relations Act is able to, or it empowers or the employers to dismiss the employees. Also on the economical part, whereby they feel they are not making profit, or this worker is causing loss to the company. So in such a case, the employers can dismiss the employee basing on the economical reasons that maybe this employee, he has caused some losses to the company, or this employee, the company is not making profits. Then there is technological issue when there is also the replacement. Maybe there is they are replacing the machine, so they will terminate the contract of those people that were doing the work of the machine. So they will, for example, if it is the farm and people were using the oils to cultivate, then they buy the tractor, they can terminate the contract. That is based on technological issue. Then structural issue, it is whereby now maybe they are restructuring the company, and they can be able to dismiss the employees basing on that. So the similar needs of the employers. So it talks about the needs of the employers. Remember, we looked at where we said the interest disputes. So this becomes the interest dispute, and the court will be able to look to where was it necessary for the employers to terminate the contracts of people basing on this fact that they have brought, or they just wanted to get rid of their workers. So the court will be able to look at those issues. Then there is dismissed for misconduct. The employers also, they have been given the powers by the act to terminate the contract of any employee, or to dismiss any employee basing on the misconduct. So this is in section 17, 3, 4, and verse A. An employee would be deemed to have been dismissed for conduct if the employer is absent. For example, if the employee is absent from work without the consent of their head of department and is absent for longer than 1 month, that employee can be dismissed. So any employee that abscond from work without getting the permission from the supervisor, it means that that is a misconduct and it can be dismissed. Now, that also can be only if one accumulates maybe 30 days of working days in a year. So those misconduct of the employees can cause to dismissal, and the act mandates the employer to be able to dismiss in such a case. Then there are dismissals based on operational. So the dismissals based on operations in section 189. So dismissals based on operation requirements by employers with more than 50 employees. This was introduced to supplement section 189. So dismissal based on the operation requirements to provide, in the case of large scale retrenchment, minimum time periods for consultation prior to dismissal. So now in this the operational based dismissal, it has to be negotiated. It has to take time. There must be consultation with the workers or the workers representative. Then the employers must bring it to the workers, and they have to compensate the workers in such a case. If there is operations, there are some adjustments that they are making in their operation. Maybe they want to reduce the labor because of the technology. So in such a case, the employers must negotiate with the employees, and they should be able to give the employees a good incentives to that. For example, as I gave as I said, these people, they have been working using the oil to cultivate. Then you have brought in the tractor, and you want to terminate their employment. So you have to you have to negotiate with them, and their representatives must be able to bring it to your attention, the requirement, or you have to negotiate this interest dispute, whereby what will be because you are doing that for your advantage. So the employees must be rewarded for that, and that is what is called operation dismissal. Then there is what is called summary dismissal. The summary dismissal, it is the employer terminates the contract of employment with or without notice. This is the most common form of dismissal. So this dismissal, it is whereby the employer dismisses the employee. Now, there must be reasons for the employer to do that. The dismissal by the employer must relate to the employee's conduct, capacity, or the employee's operational. So when we are talking about summary dismissal, then we are talking about the dismissal that should be based on the employer employee's conduct, if this person's conduct is not permitted at work or in the labor agreement, then that can be dismissed, whereby this person can be dismissed. Also, the person can be, this also talks about retrenchment. So those are the issues that comes in when it comes to trade disputes. So the employer must be able to be guided by law when it comes to dismissing an employee. It is not whereby you just wake up and say, no, I'm going to dismiss my workers. No, there must be a reason, and the reason must be enshrined in the Industrial Labor Relations Act. Then section 13 of the Labor Relations Act lays down the procedures which must be followed for making the deduction and limiting the money deducted to the trade union. So when the employers are deducting the money from the workers, there must be a guideline, and there must be a guideline that has to be given. So also the employees must know that they are mandated to contribute to the workers union certain amount for their interest. Then there is what is called collective agreement. So the Labor Relations Act basically states that an employer and a trade union holding as members the majority in the workplace may enter into a collective agreement to set thresholds of representation in the respect of section 12, 13 and 15 organized rights. So the collective agreement, it's a document that is produced by the employers and the union that stipulates the issues that relates to the employers and the workers, and this becomes the law that should govern that particular company. So the Labor and Relation Act, it gives that. So that is what mostly what is contained in the labor law. So there is Labor Relations Act, and also there is Industrial Relations Act. So these two acts are the ones that give guidance on the relationship between the employers and the employees. And these are mostly the laws that are used before court when the matter arises, the matter that concerns the employers and the employees. Now, I want us to know that it is very rare that the employer will take the employee to the court, and it doesn't even happen to a civil court. Mostly the issues that rises from the employee against the employer, where the employer has to take the employee to court. It's mostly theft matters, the matters that relates to criminal jurisdiction. But all the matters that that's the employee takes the employer are the matters that relates with they are the matters that relates with what is called civil matters. So that is how unfair the employment, the employer and the employee relationship is. So if the employee gets something like maybe the employee gets maybe 10 kwacha from the money that he was entrusted by the employers to, that becomes theft by servant, that becomes theft. But if the employer maybe deducts the money which is not supposed to deduct, that becomes a civil case. So that is how unfair these laws are. But also it is criminal for the employer if he doesn't if he steals from the workers. The worker can take a criminal jurisdiction on that, but see, it is very rare because the interest of the worker is to be compensated in monetary terms. So those are the issues that comes when it comes to trade disputes. So there are a lot of laws that governs. As I said that there are two acts that governs the relationship between the employer and the employee when it comes to disputes. And this is the Labor Relations Act and also the Industrial Relations Act. So this act must be, you as a legal personnel, as a paralegal counselor, you must be familiar with this act. So ensure that you lead through these acts and you are able to bring them before the employers and the employees. Thank you so much for having been with me, and I believe this is the last topic in the labor law. So I believe you have learned something and you'll be able to articulate the matters of law. As I always say, what we give, it is just a foundation. We just lay the foundation, but it is up to you to ensure that you dig deeper, you research, you understand this law so that you'll be able to use the knowledge accurately. Let me even quote what the Bible says. The Bible says, study hard to show yourself approved, a workman that will not need to be ashamed, but lightly dividing the word of truth. So now, the word of truth, what the Bible talks about, it is understanding the laws, understanding what is truth about a certain sphere of knowledge. So you have to understand these legal matters that relates with employers and employees. Oh, thank you so much, and God bless you.